many. 301,000 votes. Despite the so-called intimidation, my client received a paltry 27,000 votes. A small decimal of what the first petitioner received. So where is this intimidation? It is disproved by the results at the poll. It is disproved by the fact that no chief was suspended from duty. It is disproved by the fact that no chief has ever been terminated from employment. It's therefore unfair, my lords, quite unfair, for an accusation of that magnitude to be made, directed at another political player, that you intimidated persons or intimidated public officers, whereas the opposite is there. The opposite is the true position. Next one. Still with the affidavit of the Principal Secretary, the next accusation is that the third respondent went to Kisii and Nyamira talked to the IDPs in those regions and bribed them to vote for him. Those allegations, my lords, have been denied by Mr. Kivisho in his affidavit, starting from paragraph 6 all the way to paragraph 19, in which he deposed, my lords, and this cannot be denied, that this difficulty of IDPs started after the post-election violence of 2008. Successive governments have tried to resettle the victims. The current government in office, in its own budget, provided funds for the persons who had not been resettled. That budgetary provision, my lords, and this is quite important, received approval from the National Assembly. These are not funds taken away from somebody's pocket. It's the National Assembly that approved that budget. And as a continuous process, IDPs are resettled throughout the country. And the resettlement of IDPs in Kenya is within a body that is defined to in the affidavit, and which is known as the National Consultative Coordination Committee. It is that body that disburses funds to the victims. National Consultative Coordination Committee. That is the body that gets funds. The funds are approved by National Assembly and they are disbursed directly to the IDPs. My lords, there is no evidence before you that any of the beneficiaries, be it in Kisii, Nyamira, or any other part of this country, because they are IDPs also in the strongholds of the first petitioner, and they were also resettled, there is no evidence that any one of those beneficiaries was influenced by what he or she received as a resettlement from National Consultative Coordination Committee. Not a single iota of evidence. My lords, the next accusation, or before I deal with that, I leave that, there is indeed a direct authority that for any aspect to do with bribery or influence is got to be established that the inducement acted on the mind of the voter. Inducement acted on the mind of the voter and made the voter alter his decision. There can be an inducement, so to speak, in generic terms or in general. It's got to be an inducement that is specific and induces the voter to alter his mind. We shall make this judgment available to this honorable court before we rise. No, I understand we have already submitted. Sorry? This case is a high, let me get it. It's Andrew Elam against Muhammad Rahman from the High Court of Justice, Queen's Bench Division. Muhammad Rahman, R-R-A-H-M-A-N. Inducement must act on the mind of the voter and must be operative at the material time. Next allegation against the third respondent relates to Cabinet Secretary Mucheru, who is in charge of ICT in government. I start off by making this submission that that allegation is not in the petition. It only came to our notice yesterday in an affidavit that was served yesterday and which we begged time to respond to as the petitioner was presenting their case. What is this? My lords, Mr. C.S. Mucheru was never served with that affidavit, and within the limited period that we had, we were able to prepare, file and serve an affidavit by Mr. Shishil, court stamped 28th August 2017. It is not alleged, my lords, that Mr. Mucheru was campaigning for any party. What is alleged is that he was interviewed and he said he is entitled. Is that correct? Yes, he said he is entitled to campaign. So the allegation is based on an answer to a question. And surely an offense cannot be made or be, the answer cannot be the charge sheet of an accusation of such magnitude. Mr. Musheru indicated his view about political neutrality, and citing Leadership and Integrity Act, he indicated that as a CS, he is entitled to participate in the affairs of government, including making such campaigns or advancing government policy as necessary. So, my lords, in my submission, that complaint falls flat on its feet because it is ill-founded. The next one is about CS Eugene Wamalwa and Mwangi Kionjori. I'll deal with them all at the same time, and Kazungu and Barara. All those allegations came yesterday in the affidavit that was filed, and those named persons were given no opportunity to respond to any evidentiary material that was presented. And I say this once again, those are not accusations or allegations that are in the petition. Those four persons, their names are nowhere in the petition. The petition. In the petition, my lords, after dealing with all the municipal law issues, the only reference to the third respondent, I'll get it in a moment, 31. The only reference to the third respondent is in paragraph 31, and the one that would be more pertinent to this would be 32, which reads, no, petition, yes, petition. With impunity, I read, with impunity, the third respondent contravened the rule of law and the principles of conduct of a free and fair election through the use of intimidation, coercion of public officers, and improper influence of voters. No reference to any person. This is very generic, imprecise, without any particulars, and at most refers to public officers. The cabinet secretaries cannot be called public officers, they are state officers. My lords, one cannot make such a generalized allegation at the tail end of the petition, now, so to speak, drop in names of persons and give them no opportunity to give a response to those accusations. I will therefore request, my lords, to hold and find that all those allegations against the cabinet secretaries are without any foundation and to dismiss them. There is such a fundamental distinction between the public officers and their role and state officers. I have dealt, my lords, I hope, with quite a number of all the allegations against the third respondent, but I will deal with a few more because of the prejudicial effect they have or they may have on the mind of the court. Substantial time, my lords, was expended on transmission of votes. So I take that as another subheading, transmission of votes. It is common ground, my lords, that early this year, our National Assembly amended the Elections Act and infused it with technology as one of the methods that elections should be held. But let's understand where technology fits in the electoral process of 2017. Technology was there at voter registration. Voter registration was biometric. So there was full involvement of technology at voter registration. Polling date, voter identification by use of the BVI kit. Where it failed, and it failed in certain circumstances, the complementary method was used. After that, the ballot paper was manually given to the voter. BVR is BVR kit. The voter manually inscribed a symbol on the ballot. And all the processes after that were manual, including the counting and including the filling in Form 34A. All that process, which is the most integral process in the elections, was manual. And it concludes with Form 34A. Now that Form 34A, and we now see the rationale of it, you want elections or the results to be declared fairly quickly, is to be transmitted electronically to the constituency and to the National Tallying Center. But that transmission, my Lord, is nothing more than a conveyance or a conveying mode of a document. As I indicated earlier, it does not validate, neither does it take away or add to Form 34A. Because of its very insignificant weight, insignificant, my Lord, because as we have seen, agents at the polling station signed the same forms. So each and every candidate will be able to know at the end of the day the number of votes the candidate obtained at every polling station. There is no magic in the transmission of Form 34A. My Lords, in our submission, the whole purpose of this electronic transmission is a fast way of conveying the results to the constituency and to the National Tallying Center. Once that purpose is defined and delineated in those terms, any failure, not that there was any failure, but even if there was any failure, it cannot invalidate the results. Not the results at the polling station, not the result at the constituency, not the result ultimately declared at the National Tallying Center. It will be stretching logic to an illogical conclusion to say because transmission failed at this point, then those results are declared, all the results are declared invalid. I would therefore urge you, my Lords, to hold that although there was no failure in transmission, even such failure in future cannot be the basis to invalidate an election which was otherwise constitutionally compliant with all the articles or all the operating articles of the Constitution. My Lords, before you are two positions or what I will refer to as two realities. Reality number one is presented by the petitioners, and the reality, to put it very modestly, is that you allow another electoral contest to take place within the next 60 days. That reality, my lords, would mean that this nation, for the next 2 months, will be engaged in very, very contested political climate, where all manner of utterances will be made. It will engage all of us for the next 2 months until the contest is held. It is the reality, I can only describe it as a reality, which is the reality presented by the petitioner. Kenyans will be treated to the political jargon that we are now accustomed to. Attorney General reminds me, Vifaranga via computer is one slogan.
Doing that as an amicus.
Let me speak for myself, my lord. My lord and colleague sought to know from me whether I knew of any of this. I made no answer because I didn't. But he took the liberty of a man in mid-speech.
Take care, Mr. Attorney General. At least you find yourself being classified as partisan.
No, it was with a light touch, my lord. And all that is taken in good standing. There is nothing derogatory about it in my submission. A quick rejoinder is made by the other parties. We need not go to that. But all that is the rhetoric, unhealthy rhetoric in an electoral contest. Compare that, my lord, or before we compare it, let's still look at this reality and what it presents. It presents that this nation will have to contend with another presidential election, with all the invasive aspects of a presidential election. My lords, we are trained in such a way that we can make that reality look like a legal contest. A legal contest like we are advancing the rule of law. We are not really here advancing the rule of law. We are advancing an opportunity for an electoral contest. The other reality presented by the third respondent is this, my lord. To allow the third respondent move on with constituting a government, he has offered a hand of fellowship to the petitioner, offered a hand of fellowship to all Kenyans, that it is time to go back to nation building of this great nation. I paraphrase, without the eloquence of the third respondent, that the time of elections are over. Let us go back to building this nation. If given that opportunity by this noble court, what I look for or look forward to is an inclusive government where each and all Kenyans will be participants. That is the reality that I'll urge this Honorable Court to find favor with, because we cannot be in an electoral mode throughout our lives. There is no guarantee, my lords, absolutely none, that even if we were to hold another round of elections, those minuscule errors or by clerks will not take place. They will still take place. But those errors are so insignificant that they do not affect the result of any outcome. I conclude my submission. Yes, I am told by my assistants, my lords, that as regards there was a complaint about there being such a big difference between the people who voted in presidential elections as compared to people who voted for the other elections. Before we play the video, let me say this, that we have in the affidavit of Davis Shishil demonstrated that there are indeed peculiar Kenyan habits even in voting. In certain areas, and we have identified 94 areas, you will find that the outcome at one election was so high as compared to all the others. And that is nothing more than that the people in that area were in all probability voting for one candidate who was their favorite candidate. Say, for example, a member of parliament may get more votes in that area more than even the governor or the president. Which one? Number two, before we play the video, is to show, my lords, that if you compare Jubilee Party election results for the post of governor or the post of senator or woman rep, members of parliament, you see that in all of them the results are in the region of 53 to 60%. 53 to 60%. We play?
Yes.
Okay. Now we'll show a short clip and then I'll be concluding. Yes, it won't take long.
Okay. It's not a clip. It's just a video. So for the presidential, that is what we have. Our client had 54.3%. Then we go down to the gubernatorial. He had 53.2%. And the next one is now the pattern. The one marked red represents Jubilee. We can see that it is more than half of the map of Kenya. And that explains the number of governors. Jubilee has 25 seats. We have KANU, which is an affiliate party, which has 1. That takes it to 26 seats. Way down to the Senate election results, we find that Jubilee Party has got 51.1%. The Senate election results, Jubilee, the voting pattern is as shaded, representing the 51%. Parliamentary election results, we find that the Jubilee Party has 48.6%, together with other affiliated parties as shown. Then we go to that is the total number of the positions. We go to the women representative. At the women representative, we have Jubilee having 55.3%. The voting pattern is shown. Then finally, with that is it. Thank you. Thank you.
So, my lords, from all those results, and these are 6 elections held the same day, you will see, my lords, that the result for the president is not dissimilar, and that is the point I wanted to make, is not dissimilar from the results in the other 5 elections. As a matter of fact, one would say they all follow within the same range. So any aspect about votes being added, votes being deducted, it's really not scientific, it has no basis, and it's yet another allegation, which is a red herring. I therefore conclude, my lords. I started from a constitutional argument point of view because in my submission, a contest regarding presidential petition or presidential outcome ought to be litigated within the confines of the Constitution at the very least, or bearing those articles in mind at all times. And in my submission, the quantitative test is at the highest level. Highest in the sense that one must gain not less than 1/2 of the votes cast. That is unique to the presidential results. It's not similar to the other 5 results. In the other results, actually one who has even 21% or 20% or whatever percent could be declared the winner. Number 2, my lords, having demonstrated that elections were held within the expectation of the Constitution, it will be unfair, in my submission, to invalidate them for infractions, which infractions we have demonstrated do not exist. And finally, my lords, that as regards the accusations against state officers, those allegations are without any basis whatsoever. They were not pleaded in the petition, and they cannot be, so to speak, added at the tail end of the hearing of this petition. My lords, my learned friend, Mr. Ahmed Nasir, will now conclude all the submissions that we have made.
My Lord Chief Justice and Judge of the Supreme Court, I think one document we should have really highlighted right from the start, but we didn't do, was the affidavit, my Lord, by the 3rd respondent. And I would just like, very briefly, my Lord, just to refer you